This Megan v. Milagro legal battle has moved out of the courtroom and into the trenches. We're no longer just talking about damages and who's media. Now, we're tracking a 23-page cyberstalking filing and a strategic push to reinstate the defamation verdict from the jury. This cyberstalking injunction details the coordinated attacks against Megan the Stallion from Milagro Gramz, intended to punish her for reporting a violent crime. It cites evidence such as Milagro's role as a paid surrogate for the Peterson family, her liability found in the promotion of an AI deepfake, and her online stalking of Megan's private residence through saved aerial screenshots. Megan's legal team argues that monetary damages alone are insufficient because Milagro has remained undeterred by the jury verdict. She continues to mock Megan's emotional distress and framing her ongoing harassment as artistic expression via a planned mixtape because, in her words, the only place you can bully people and talk crazy is in the studio. If granted, the injunction would impose strict legal limitations for 5 years or 60 months, including the following mandate: no contact, a total ban on any direct or indirect contact with Megan, including via social media or third parties. A stay-away order. Milagro must remain at least 500 feet from Megan's residence and 1,000 feet from her musical performances. Content removal. Milagro must remove from the internet all statements and postings that form the basis for the jury's liability verdict. Speech restrictions. A prohibition on repeating defamatory narratives regarding Megan's trial testimony, mental and emotional state, or alcohol use. Privacy protections. A ban on disclosing Megan's personal identifying information, such as her home address or phone number, and a permanent block on sharing the deepfake video. Incitement ban. A prohibition on any communications intended to incite third parties to engage in threats or violence against Megan, her family, or her professional team. On December 23, 2025, Megan's team filed a Rule 5059 motion to restore the jury's original finding of liability for defamation, which the judge partially set aside due to the media defendant technicality. They argued the court already ruled Milagro was not a journalist and that allowing the media defendant label to reach the jury was a legal error that should be corrected as a matter of law. And under Florida law, if you're a media defendant, the plaintiff must give you a warning, known as a pre-suit notice, before suing you. Megan didn't do that. Why? Because twice before trial, the court ruled that Milagro was not media. I even covered it in my series. The judge ruled that Milagro was not a journalist herself. But at trial, though confused, the jury partially checked boxes on the verdict form labeling her a media defendant. Megan's team is now arguing a law of the case violation. They are essentially telling the judge you can't change the rules in the middle of the game. They argue the First Amendment protections for the press shouldn't cover a paid operative running a smear campaign. Milagro's legal team has fractured back-to-back after the trial ended because Milagro is reportedly unable to afford their continued representation. Milagro actually failed to file a response within the required window. The judge noticed the silence and, refusing to let this drag on, issued a blunt order with the final deadline of January 9, 2026 to respond. The warning attached to it was very clear. If Milagro fails to respond by this Friday, the motion will be granted by default. I'm Dr. Q, and this is RealQuickMedia. I'll keep you updated on the latest as we finalize this social media saga. Be sure to like, comment, share, and subscribe so you don't miss the next drop.